So case study one, Prodigal Son, and this is a fairly common story. We see this kind of thing a lot, so much so it's in a document that's several thousand years old. Adam and Eve, two sons, Cain and Abel. Abel has been working diligently for Dad for many years in the family business. The family business is operated through a company called Eden, and Eden is owned by a family discretionary trust. So great structure, certainly better than the structure that I just described, because we've got a family discretionary trust as the shareholder of the company, as opposed to mum and dad. It's also better than flipping that on its head, where we have the business held by the discretionary trust and having to use a bucket company to reinvest through retained earnings. Business is worth $10 million, and that's all a nice, safe, happy part of the world. On the other side of the family, Cain, Abel's brother, has had one unsuccessful business venture after another. He's losing money left, right, and center. Mum and Dad just shelled out $1 million for the latest venture, which was lost. And Cain has come cap in hand back to Mum and Dad for another venture yet again, and Adam and Eve have finally said, no, that's enough. So he disappears and hasn't been heard of for 3 years. In addition to the company and the discretionary trust they control, Adam and Eve have a super fund with $2 million in it. They own their own home in Sydney worth $3 million. They're virtually semi-retired, and they're considering moving to sunny Queensland or Byron Bay, like most New South Wales people are at the moment. So other relevant factors: Dad, Adam, sole director of the trading company. Adam and Eve are personally the trustees of the family trust, so for what that's worth, that's not ideal. Adam's the principal or appointer or guardian or whatever you want to call him of the trust, so can remove the trustee. And the accounts of the trust show that Mum and Dad are owed approximately $4 million in unpaid present entitlements, but the accounts also show there's a $4 million loan that the trust has made to one of Cain's investment companies. So effectively, that loan and that unpaid present entitlement are offset on the books. There's no loan agreement in place, though, and in fact, Cain's company was liquidated by creditors many years ago. Shares in Adam and Eve's company, Eden Co., recorded at their subscription price of $1, which is not surprising. So what are Adam and Eve's objectives? So remember, the first stage in all this process is to actually try and work out what the family wants. Well, because Abel's already effectively in charge of Eden, they want him to effectively have ownership of it, but not quite yet. Adam and Eve's rough mental calculations, including the business, is that their assets are worth $15 million, i.e. the business worth 10, their house worth 3, and the super worth 2. And they've not really thought about how that's all dissected and how things work between them. They're relatively happy, despite Cain's behaviour, to leave him something, and they're prepared to give him either 10% of their estate or $1.5 million, whichever is the greater, but on the strict condition that Abel definitely gets control of the business. And Abel, from his point of view, he's very concerned. He doesn't quite share Mum and Dad's naive faith in Cain. He's been speaking to an old school friend who's still in touch with Cain and found out that Cain's dating a lawyer who has told him he's entitled to half of the estate, and Cain will, in fact, sue the old man the minute his bones are cold. So, not very nice behaviour. So let's have a look at what the estate comprises. So, in fact, the estate, if Adam and Eve pass away, that's not quite right. I've got that wrong. Sorry. The house is worth $3 million. No, that's right. The house is worth $3 million, but they also have an unpaid present entitlement owing to them from the trust worth $4 million. So, in fact, they're not worth $3 million in their own name. They're, in fact, worth 7. Self-managed super fund, on the other hand, well, that's pretty straightforward. It's got the assets of 2. Discretionary trusts, yes, I have got this wrong. So its assets, shares worth $10 million. The loan to Cain's company, though, it's on the books for 4, but it's actually unrecoverable, so it's worth nil. However, the discretionary trust has a liability back up to the estate, back up to Adam and Eve personally, for this unpaid present entitlement. So the total assets effectively of the discretionary trust, net assets look more like $6 million. So what are our concerns with all this? Well, the estate still includes the $4 million unpaid present entitlement. The trust has the liability to the estate, but doesn't have the asset. What happens with the super fund balance? What happens if Adam and Eve die? What happens to that super fund balance? What family provision claim can Cain bring? If you weren't in New South Wales, generally that would only be against the estate. But bear in mind, the estate in any jurisdiction comprises the house worth 4, but also the house worth 3, but also the unpaid present entitlement worth 4. So the estate's worth 7 alone. But over and above that, New South Wales, you do have notional estate provisions. I know we've got participants from all around the country here. It's really only New South Wales you have to be concerned about for these notional estate provisions. But if you are in New South, it does create some pretty significant issues. What notional estate provisions allow for, and it's under the New South Wales Succession Act, it allows for a disappointed beneficiary to bring claims not just against the estate, but also the testator's notional estate. The notional estate comprises anything the testator has transferred out of his or her name within 3 years of them passing away. So greatly broadens the scope of potential family provision claims in New South Wales. But what about discretionary trusts? So discretionary trusts are structures that have never formed part of the estate. They're not, and we can go through lots of cases that talk about the interest that beneficiaries have in discretionary trusts, but it's certainly not something you can bequeath. Can the Succession Act of New South Wales apply to New South Wales discretionary trusts? And the answer is yes, based on authority of Highland and Burbridge and Hitchcock and Pratt. Those are cases which establish that if the testator effectively controls that discretionary trust right up to the time they pass away or within 3 years of them passing away, then that testator can effectively appoint the capital, the corpus of that trust to themselves, and thereby control that trust in such a way as it could potentially form part of the notional estate. The fact that the deceased has not done so simply means that all the assets of that trust then therefore comprise the notional estate for New South Wales purposes. Same thing applies based on a case called Ormsby and Ormsby in relation to superannuation benefits. So that's our state of play. So what are our potential solutions? Well, firstly, let's have a look at this unpaid present entitlement. Can we forgive it? Can the estate forgive the unpaid present entitlement from the discretionary trust? You have to have a look at the commercial debt forgiveness provisions, work through those. We used to be able to forgive things up until recently, and I can't remember the particular ruling, but we could forgive things between companies and trusts and individuals based on natural love and affection. That no longer applies, but it probably doesn't matter. In fact, it definitely doesn't matter in this case anyway, because the parties are related. And I won't bore you all with how Division 245 works in conjunction with the market value substitution rules. But effectively, forgiving the UPE between the parties will mean that there's no practical effect in terms of the estate. And so long as there are no other Section 109XA issues in relation to unpaid present entitlement to corporate beneficiaries, we should be right to simply forgive that unpaid present entitlement. I suppose you've got the potential application of Section 100A if the tax office has its druthers, but if this is an unpaid present entitlement that's been in place for many years, then I think it's pretty unlikely that tax office could successfully apply that, but who knows, they might give it a crack. So what else can we do? Well, we can ensure the self-managed super fund does not benefit the estate. We could do a non-lapsing by death nomination to Able. Apparently that still forms part of the notional estate under that Ormsby case. What you could do instead is withdraw the assets from the super fund and actually gift them to a discretionary trust or Able now, but that could potentially form part of the notional estate, although the 3 years will start to run. The bigger problem, though, obviously, is you lose the tax benefits of having it within the self-managed super fund environment. So do that with great caution, but maybe that might be a potential option. And you could have a think about using discretionary trusts to either siphon the assets off through gifts and loans, or you could potentially transfer the assets into the discretionary trust itself. Is there a problem with that? So if we have a lot of assets in discretionary trust, and assuming that we don't have the notional estate provisions, well, firstly, let's deal with the notional estate provisions. So based on the Pratt case and the Highland and Burbridge case, we could potentially completely hand the control of the trust across to Abel by changing the principal from Adam to Abel, changing the trustee. We can insert a corporate trustee to replace Adam and Eve as individuals. Abel can be sole director and shareholder. That way there can be no argument at all that Adam and Eve still control that trust to the extent they could appoint capital to themselves. You have to be very careful of de facto control, and I think Ken and Spry is probably a good case to just touch base with there. Obviously that's a family law case, but it's relevant specifically in the family law context to control of discretionary trusts. Doesn't immediately have any kind of precedential value to us in this case, but the concepts are worth having a look at. And if all else fails, well, I guess you can move to Queensland to get around the notional estate provisions. Just before I leave the trust issues though, I do want to spend a little bit of time on the two Victorian cases which have excited us all recently. They're not in the paper here, but there was a presentation done by one of my colleagues here at McCullough Robertson, senior associate called Paige Edwards, a couple of days ago, and she very kindly, and this is a paper for 10, so you'll be able to access this through the TENS database. It's a paper called "A Matter of Trusts: Impact of Trust on the Estate Plan." Really helpful paper to have a look at, and a presentation to have a look at in this context, and it gives a pretty good analysis of two key cases that are, I think, going to become increasingly prevalent in the context of family disputes and discretionary trusts. The first case, not a discretionary trust case, it's a superannuation case, a case called Marcella and Wareham, or re Marcella, 2019 VSC at 65. And that was a case where a superannuation fund was established, and the members of that fund were the deceased and the deceased daughter from her first marriage as trustees. The deceased was the sole member of the fund until her death. Sorry, get that right. Daughter wasn't a member of the super fund, but was a trustee. And deceased's husband of 32 years survived her. Husband was not the father of the other trustee of the super fund. So deceased obviously passed away. Daughter became the sole trustee, and she appointed, using her discretion under that super fund deed, appointed her own husband as co-trustee and paid all the benefits of the fund to herself. So nothing unlawful about that. Certainly she was entitled to both appoint a co-trustee, in fact was required to appoint a co-trustee, and she was certainly entitled as a death benefit beneficiary to appoint all the income to herself. But the deceased's husband of 32 years, who wasn't the father of the daughter trustee, sought to have the trustee removed, the trustees removed, the daughter and her husband removed, and the funds repaid to the super fund. And this was on the basis that the trustees did not exercise their discretion in good faith and after real, genuine, and genuine consideration of the dependents of the deceased. So effectively, the husband argued that the daughter did not consider him as a potential beneficiary. Trustees' response certainly would have been my response back in 2018, was that, hey, the trustees have absolute discretion as to how to make the payment, and they're not required to provide reasons for the decision. What was really interesting about this case is the court, and there's been some commentary in New South Wales, and probably, well certainly Bernie can give a lot more of the inside story about how this all happened in Victoria. Sorry, I think I said New South Wales. How this went down in Victoria, and the role of this particular judge in kind of acting in a way that was a little bit surprising, perhaps, in the circumstances. But the court basically looked at both the attitude of the deceased, the attitude of the trustees, the daughter and the husband, against the deceased husbands, and the nature of the relationship, and the fact that it had in fact irretrievably broken down. And also took into account the fact that the husband didn't have a lot of money. That's the deceased husband didn't have a lot of money, and it was therefore surprising and in fact improbable that the trustees wouldn't have considered a favourable exercise of discretion towards that husband. So the consequence of that case was, despite having the power pursuant to the trust deed and everyone's common sense understanding of how these things work, the court ordered the trustees to repay the money to the super fund and in fact resign as trustee. So a really important case, gives us an idea, albeit in the superannuation fund context, but the principles are definitely as applicable in discretionary trust context as well. So in our case study here, we have to be super careful. If we're handing all the control over to Abel, what does that mean if Cain is still a potential beneficiary of that trust? And do we consider potentially excluding Cain as that beneficiary, which is probably a very good idea. We obviously have to watch the potential for resettlements and stamp duty in some jurisdictions, but since Clark's case a number of years ago, I don't think we have any concern from a CGT position that by removing a beneficiary, even a default beneficiary for that matter, that we're actually creating a new trust. The other useful case to look at in this context is a case called Callus, C-A-L-L-U-S, and KB Investments. It's a case from just last year, 2020 VCC 135. I think it's VCC. Victoria County Court 135. So it was heard was handed down 26th of February last year. Pretty important case. Despite a fairly awful set of circumstances, and as I was just saying to Paige, my associate earlier, if my children behave like this, I'll certainly come back and haunt them. It was a very ugly family dispute between siblings and the children of Kenneth and Beverly O'Neill, whereby the trust was hijacked, assets were transferred out of the trust, etc., etc. The circumstances were pretty awful, but in the particular cases, and distinguishing Marcella, the court decided that in this, it wasn't appropriate to remove the trustee and transfer the assets back. So very much a evolving area of law. We have to look at it very carefully, be very aware of these cases and the potential for trusts to be attacked by the courts. They're no longer the no holds barred, you have complete discretion to do whatever you want vehicles that perhaps we thought they were a few years ago. And certainly, these are Victorian cases, so they don't necessarily form precedents in other states, but they're certainly highly persuasive on courts in other jurisdictions. So back to our case study, what are our outcomes? Well, the worst case scenario for mum and dad is Cain has a potential claim on a proportion of the full $15 million. The best case scenario is we can reduce the assets in the estate just to the family home, i.e. $3 million, or potentially further if we can get some equity out of the family home or transfer the family home into some other vehicle. So there's a wide range of potential outcomes there, something to be very, very conscious of when doing these estate plans, that we have to take into account not just assets in individual names, but also how they interact with other assets within the structure. Okay, so moving on to case study 2. Essentially, this sort of provides a bit of an example of how we could have, and still can if you're aggressive, restructure a family group in a way that provides some benefits to the family in the way we want, but it's something that clearly the tax office would have some concerns about. So proceed with caution. So the structure basically is very simple. We have a private company which is completely owned by a discretionary trust. It has a bunch of retained earnings and a bunch of different assets. Those assets include business, cash, property, and for the sake of this simplified argument, they're all worth the same amount of money. We have a business worth $1 million, cash of $1 million, and property worth $1 million. And we have 3 adult children who have different needs and have requested that the different sons receive different assets. That's what we've got. Arthur wants $1 million cash. Barry is happy to take over the business, and Charles is happy to take over the property. Now, you'll no doubt pick a whole bunch of problems with this particular case study, but I'm just sort of using it to highlight some of the key issues and where the tax office looks at the restructuring concerns that I'm going to raise. So one of the solutions we could have adopted in a more innocent time is we could have used rollovers to interpose new companies. We could have moved assets between companies either by accessing concessions, such as the small business concessions for the company, or simply declaring a dividend for the cash. Then we could have used demerger relief under Division 125 to separate that out into new companies. And then we could have split the original trust so that Arthur, Barry, and Charles separately control each company. So neat little option. We start off by entering these new companies. We've got originally a company just called XYZ. We set up XYZB and XYZC, potentially declare a dividend up, potentially transfer the business across. We could even consolidate and do that without too much drama. In virtually every state, or in fact every state that I'm aware of, you wouldn't pay stamp duty to make those transfers. So we end up with the cash, business and property in the different entities, different companies. We then split that out so that discretionary trust is the shareholder of each of those three. Then we split the trusts so that Arthur controls the first trust, Barry controls the second trust, Charles controls the third trust. Well, actually, let's get that right. We don't have different trusts. We don't have three trusts there. We have different assets controlled within the same discretionary trust by each of three different trustees. So we could effectively achieve what we're looking for if we take advantage of both those trust splitting, I won't say rules, but trust splitting options and using the demerger provisions. So great in the theory, but tax office has some significant issues with that type of arrangement. Firstly, we have to look at TD now 2020/6, which replaced TD 2019/D1, and not significantly different, but there are some differences which I won't bore you with, but certainly happy to take that offline if you have any questions and you're looking at restructuring. The key to both the draft determination and the final determination is the ATO's very, very narrow interpretation of section 125.71C, which basically is that under the restructure, the entity acquires a new interest and nothing else. So this nothing else provision has been seized upon by the tax office to effectively reverse a long-standing position the tax office had about how restructures can work, to effectively say, look, we need to have a look at the restructure in isolation. If something else is going on, if there is some other benefit happening on the side, or there's some other part of the restructure, then we're not going to be happy about it, and we're not going to allow you to apply the rollover in 125. So it's an area which, even though we've got this now finalised tax determination, you need to proceed with great caution. You do see some class rulings that are starting to appear around demergers, and you will increasingly see private rulings and potential litigation in this area as well. The tax office's position is pretty clear in the finalised TD. It's worth looking at because it does have a number of examples, and you can try and squeeze yourself within those within the grey areas of those examples, but do so definitely at your own risk. Similarly with trust splitting, the Commissioners finalised another tax determination on trust splitting, which took a couple of years to come out. I think that's 2019-4, if I can read my my writing correctly there. And the Commissioner's view is that there's very limited circumstances in which a trust split will not create a new trust. Arguably completely wrong, based on Clark's case, which I referred to earlier, but certainly that's the Commissioner's position. Fortunately, though, the finalised TD goes a little bit, well, doesn't quite go as far as the draft determination went. The draft determination basically said all trust splitting is bad under all circumstances. The finalised determination does give you some ability in some circumstances, which might apply in our example here. You have to have a single tax return, that's fair enough. You have to have no limitation on rights of indemnity. That's pretty important and seems to be a very big driver in all these things. So what that's all about is, if we go back to our case study, not terribly relevant here because we've got trusts which are shareholders of company, and so theoretically at least, they shouldn't have any exposure to the risk of the company. Not always the case, as is the example that I mentioned before I went through the case studies with a current case of mine. There is potential for that corporate veil to be pierced in a whole range of ways these days, but let's assume for the sake of the argument that Solomon's still good law and the shareholders don't have any exposure to the risks of the company. Well, in that particular circumstance, we don't much care about the rights of indemnity, because what that's all about is if Arthur, in his capacity as trustee or director of the trustee company for ABC Trust, does something that exposes the assets that he controls to risk, then creditors of Arthur Co. Proprietary Limited need to have the ability to access the assets of Barry Co. Proprietary Limited and Charles Co. Proprietary Limited in their capacities as trustees of different assets within the ABC Trust. So effectively that means that you've got cross indemnities between the different silos, so to speak. The tax office's view is as long as those indemnities survive, then we're relatively happy with that. But if you prepare as part of your documentation a deed whereby those rights of indemnity are waived, then that's the kind of issue that they'll be looking at as potentially creating 3 new trusts. And look, I have some sympathy for that argument. It does start to look a lot like 3 different trusts if you don't have common indemnities between them. Probably more controversial is changes in beneficiaries. That really shouldn't make any difference. But if you've got a family group, then it probably doesn't matter anyway. So you can still do trust splits, but you have to be very careful that you're not ticking any of those boxes. And I think from memory, in that finalised TD, all 3 of those things must apply. So there must be a single tax return, there must be no limitations on rights of indemnity, and there must be no changes in beneficiaries. So again, depends on how aggressive you are. You certainly can still do trust splits, but be very aware of the finalised determination. You can still do demergers, but be very aware of this nothing else provision. The tax office has said in the finalised determination, TD 2026 for demergers, that it doesn't matter if the steps are separated by a number of years, but obviously that would help. And in a family context, you could possibly do that in such a way that these 3 steps are spread over a period of time. Yeah, I would strongly suggest in this circumstance, though, because there is an outstanding TD, that you get private rulings, or sorry, 2 outstanding TDs. You get private rulings on both these issues if you're proposing to proceed, and there was a fair bit of money involved. Okay, so to wrap up, takeouts. I think goes without saying, but still needs to be said, that every family group is different, every need is different, every structure is different, and we have to put different solutions in place that tailor them very specifically to the needs of that family group. And I think, again, this is something that we overlook a little bit as professionals. Certainly I've seen colleagues with a particular structure they're very fond of really push that forward as a structure that solves all problems. It's not the case that you can have a one-size-fits-all approach to this, and you have to take a lot of time to understand the client's objectives and really get to understand what their situation is. And you can jump to conclusions very quickly in this job, particularly if you've been doing it for a while. And you have to very much come to each client meeting with a completely blank slate. Don't have any preconceptions about what the clients want, and really take the time to understand what they're after. Now, what all that means is you have to spend a very large amount of time getting your head across not just what it is or what's there at the moment, but also what they want and how to achieve that. So, you know, the worst thing you can do in these situations is try and shoehorn this into a $2,000 estate plan. Some of these things can take a lot of time, and you need to charge accordingly. Now, in some circumstances, there won't be enough assets within the estate to really justify that. For example, a $3 million family group like the one I just went through probably wouldn't necessarily justify the kind of work that you would need to undertake to achieve the kind of separation they want. But you have to give the clients the option, because you just never know. Maybe they'd be prepared to go to the extent of getting private rulings to see if that restructure worked, because their objectives were sufficiently strongly held. You have to pick from the range of tools to determine the best, or quite often the least worst outcome. And of course, that recognises that there will be trade-offs. There is, like I said, no perfect solution. There's certainly no one-size-fits-all solution, but sometimes you just won't get a perfect solution. So the perfect outcome from a purely estate law perspective might cost a significant amount of tax to achieve, or vice versa. And like I said, you have to be aware the ATO's attitude is not just skeptical, but also evolving. And you are foolish if you don't consider them virtually a co-partner in your estate planning objectives, because if they get hold of what you're trying to achieve after the event, they'll certainly insert themselves if they have to.